The topic of leases is a huge topic, so I will break it into 2 episodes. Today, I will discuss 3 key points to keep in mind when you are signing a new lease or taking over a lease when you're buying a pharmacy. I will discuss 3 other points in a separate episode. Point number 1, the term of the lease. For how long is the lease? 10 years, 15 years? If you are signing a brand new lease, I recommend that you negotiate a lease of at least 15 or 20 years. That is, of course, including renewal options. Why? Because if you are starting a pharmacy from scratch and signing a new lease, it takes a few years to break even and build up the pharmacy volume. You have to make sure the lease is long enough for you to grow the pharmacy and still have at least 10 years left on the term of your lease when it comes time to sell the pharmacy. The main reason is because most banks will not finance the purchase of a pharmacy unless the pharmacy has a lease that has at the very least a 10-year term so they can amortize the loan over 10 years. But most buyers want a minimum of 12 to 13 years left on the lease when buying. And so if you are purchasing an existing pharmacy, you need a lease with at least a 10-year term. If you're opening a pharmacy from scratch, you need at least a 15 to 20-year term so that you can develop the business and hopefully sell it with at least 10 years left on the term of the lease. In terms of renewal options, when negotiating a brand new lease or taking over a lease, you should ask the landlord for as many renewal options as possible. The more, the better. The more renewal options you have, the longer is your lease. What is also important is to make sure that your right to renew the lease is on the same terms and conditions as your current lease, except of course for rent, which is going to be negotiated between you and the landlord when you're renewing your lease usually. But you have to make sure that you renew your lease on the same terms and conditions so that the landlord does not come up with new terms like a demolition clause, for example, that you don't have right now in your lease when it comes time for you to renew. The renewal should be on the same terms as the current lease you have, except for the rent rate. As for the rent rate, you should have a clause in your lease saying that when it comes time to renew your lease, rent will be determined based on the fair market rental value of similar properties in the area. This way, the landlord doesn't just come up with an unreasonable rent rate when you're renewing. It's also very important to include an arbitration clause in there to make sure that if you and the landlord cannot agree on rent by a certain period of time, say 2 or 3 months, that you can go to an arbitrator who can then decide rent on your behalf, you and the landlord. An arbitrator costs less money than going to court and will also determine the rent once and for all. Number 2 is the use of the space. In any lease, you have to make sure that the permitted use, the allowed use of the space fits with your plans for your business. Not just your current plans, but your future plans for your business. For example, are you planning on using the space just to operate a pharmacy, or will you be operating both a pharmacy and a medical clinic in this space? Let's say you want to start by operating a pharmacy and then add a medical clinic later in the future. Even if it is later, when you are signing a lease, you should always make sure that the permitted use of the space reflects your current plans as well as your future plans. And number 3 is the demolition clause. Now let's talk about the dreaded demolition clause that we now find in many leases. What do you do if the landlord has a demolition clause in the lease? Do you walk away from the deal or do you proceed? To be honest, many leases now have a demolition clause. And so in my opinion, the mere existence of a demolition clause in a lease should not be the only reason for you to walk away from a deal. Otherwise, you would be walking away from many deals. Having said this, when you see a demolition clause, it is your sign that you should do more research, more due diligence regarding the premises, and the reason the landlord has this demolition clause in the lease. Try to find out whether the landlord has concrete plans to demolish the premises, or did he just include the demolition clause to protect his rights, an option to be able to terminate your lease if in the unforeseen future he wants to demolish the premises or sell to a developer or who wants to demolish the premises. Is the landlord demolishing in the next year, or does he not have any plans to do so but wants the demolition clause in there to keep his options open? Some pharmacies have demolition clauses that were never exercised by the landlord, while others were served with written notices of termination of the lease because of the landlord's plans to demolish the premises. Which brings me to my next point. Once you have done your research and decided to proceed and accept the demolition clause, you must then make sure to include certain terms to protect you and your business in the event the landlord exercises the demolition clause. First, you must make sure that the landlord is obligated to give you prior written notice of its intention to terminate your lease to demolish the premises. This written notice should be as long as possible. Usually we see between 12 and 18 months of prior written notice, which means the landlord must let you know of its plan to terminate your lease to demolish the premises at least 12 to 18 months prior to the termination of the lease. This at least gives you time to relocate your business. Other items you can ask from the landlord are relocation costs. You should also restrict his right to terminate the lease to only in the event of demolition. Many landlords will want to put in the lease that they have the right to terminate the lease if they want to sell the building or renovate the building. That's when I advise my clients to negotiate with the landlord that they can only terminate the lease if they want to demolish, but that's it. In the event of renovation, depending on what part of the property they're renovating, you may still be able to operate the pharmacy. And in the event of a sale, that they're selling the property, the new owner should be in a position to assume your lease and keep you on as tenant. Again, these are points of negotiation. Sometimes the landlord agrees, sometimes the landlord does not agree. It doesn't hurt to try. And then you can decide how to move forward based on all of the information that you gathered, as well as your negotiation with the landlord. If you're signing a new lease for a pharmacy from scratch and the landlord insists on a demolition clause, then make sure you have a certain amount of time before the clause kicks in. For example, 5 or 10 years before the landlord then has the right to demolish the premises. This is MARIANNE Keriakos, and I will see you on part 2 of the episode on leases. We're going to be having another episode where we will be discussing 3 other points on the negotiation of leases. I will see you next time.